Welcome to Talking Legal with Templars. My name is Dayo Okusami. I'm a partner at the firm. Today, we have a special guest, my partner at the firm and head of our disputes department, Adewale Atake, Senior Advocate of Nigeria. Welcome, Wale.
Yeah, thank you, Dayo. I'm delighted to be here.
So today, Wale, we're talking stabilization clauses and how it impacts on companies under the Petroleum Industry Act. But before we do a deep dive, why don't we just kick it off with what is a stabilization clause in the first place?
Yeah, Dayo, as you know, all investors, when they get into a country and enter into a contract of a long term with their host state, usually want a stable legal regime that will apply to their contracts. And so stabilization clauses are essentially to ensure that this stable regime apply to the contracts of an investor and to protect the investor against any material or adverse change in the law which could materially impact the investment of the investor. Now, these stabilization clauses could take any of the following form. It could be a freezing stabilization clause or an economic equilibrium clause. The whole essence is to ensure that the investor has a stable legal regime applicable to his contract, and should there be any change in the regime which could legally or materially impact the investment of the investor, then the investor should be compensated by stabilizing the contract.
Wale, thank you for that. So we've gotten an overview of stabilization. Now let's start getting into the Petroleum Industry Act, the PIA. The PIA has provisions for voluntary conversion of licensing and leases under this act. Could you give us some context into how stabilization plays into that?
Because of the very extensive changes to the Petroleum Act, the PIA makes provision for gradual transition from the Petroleum Act regime to the PIA regime. And one way of transiting into the PIA regime is by voluntary conversion. Of course, you may choose not to transit into the PIA regime, in which case you remain under the Petroleum Act. And any stabilization provisions applicable to your contract continues to apply. You continue to enjoy such stabilization guarantee until the expiration of the underlying OML.
Okay, oil mining lease.
Yes, from which point you transit into the Petroleum Industry Act.
Okay.
Now, you may, however, choose to voluntarily transit into the Petroleum Industry Act. And in order to do so, you may have to sign what is called a conversion contract with the NNPC. And this conversion contract must contain the following terms: termination of all arbitration and litigation cases which are pending in courts. All stabilization provisions previously provided under a contract will be declared null and void.
Oh, wow.
And you will have to relinquish about 60% of the acreage area. Those are the base terms for the conversion contract. Now, as you can imagine, when you voluntarily convert, like I said, you lose your rights to stabilize.
Yes.
Now, and this could create a problem in the context of a PSC.
Okay.
Now,
yes. Yep.
With regards to joint ownership of assets,
yes,
this may not be much of a problem.
Okay.
Because
so under the traditional joint ventures, that's not much of an issue.
That's not much
PSC,
of yes.
It might be an issue.
It might be an issue.
Okay.
And the reason why it's an issue under a PSC is because the Petroleum Industry Act provides that the right to transit is exercisable by the leaseholder.
Okay.
Under the PSC, NNPC is the leaseholder.
Nigerian National Petroleum
Corporation
Okay.
is the leaseholder.
Yep.
Same party is the party who gave you your rights
Yes.
to stabilize under the PSC. It guaranteed that right to you under the PSC. And so, if NNPC for any reason wanted you to lose your right to stabilize, all NNPC needed to do was to transit from the Petroleum Act regime to the Petroleum Industry Act regime. And when it does so,
Yes.
you lose any stabilization protection it gave you previously under your PSC.
Petroleum Act.
And so, for me, that provision needs to be revisited. It will need some form of legislative amendment because that could not have been the intention of the lawmaker. And so, for me, pending when that amendment is made, I will expect that the decision on whether or not to transit should be jointly taken by both NNPC and the PSC contractor. Otherwise, we'll be confronted with such a problem where the contractor may have to lose his right to stabilize as a result of a unilateral decision by the NNPC to voluntarily transit.
Which could have huge financial implications on the operation of that contract. Wale, thank you for that. It's pretty interesting to get into this deep dive of the legislation as well, and kind of how it interplays with real life. You mentioned that TEMPLARS are helping international companies renegotiate their PSCs currently under the PIA. It's also interesting that you talk about stabilization because one of the largest arbitrations against the Nigerian government, a $2 billion arbitration award, involves stabilization as well, that TEMPLARS acted on behalf of the International Oil Company. Now, to the question regarding its application on the PIA, you mentioned Section 305 of the Petroleum Industry Act and limitations. How do the limitations under Section 305 of the Petroleum Industry Act impact on stabilization?
First, I must clarify the position that Section 305 of the PIA is not a bar to stabilization. It merely limits an investor's right to stabilize against.
Okay, so it's a limitation, not a bar.
It's not a bar.
Okay.
Against the federal government. And these limitations are only in respect of certain types of laws. And these laws are generally applicable taxes,
okay,
such as the Company Income Tax Act, the Value Added Tax Act, the Withholding Tax Act. Okay. These sort of laws are considered to be statutes of general application.
Okay.
And so, a change or an amendment in any of such laws will not give
a right to stabilization.
Yes, give a right to stabilization.
Okay.
Previously,
under the Petroleum.
Yes, you could stabilize against such claims under the Petroleum Act.
Okay.
But under the Petroleum Industry Act, you could no longer stabilize against an amendment or a change to these sort of laws.
Okay.
Now, there are others, and laws also impacting levies and payments that comply with modern principles of environment, labor law, health, and safety.
Okay.
Now, an introduction or a new law in this area or an amendment to the law in this area will also not give you a right to stabilize. And the last is a law impacting taxes and levies in order to guarantee Nigerians' commitment to any international treaties on climate change.
Okay.
Yes. An introduction of such laws into our legal regime, or an amendments
Would not
to the
trigger
law will also
not trigger a
not
stabilization claim.
trigger
Okay.
a stabilization claim. And I believe the reason for Section 305 came about as a result of the lessons learned by NNPC and the federal government in the PSC disputes that happened in this country between 2007 and 2011.
Wale, so just by way of clarification, so there were a number of disputes between international oil companies and the NNPC under their PSCs that started in 2011 that TEMPLARS were advising on. You're saying NNPC learned from that, and that is having an impact on this. NNPC and the Nigerian government
may have had an impact on Section 305 because stabilization,
yes,
as you know, played a big issue in those disputes.
Correct.
And it was, for want of a better word to use, it was easy for the PSC contractors to trigger the stabilization claim against the NNPC and the federal government as a result of the broad stabilization provisions in the 1993 PSCs.
Right.
And so the federal government may have learned their lessons in
and
giving
restricted
broad stabilization clauses. And so what they have done by Section 305 is to ensure that going forward, you will no longer have broad stabilization clauses, but stabilization clauses which are more or less confined or restricted to certain
triggers. Okay. So, and that's very interesting because then there's the learning curve in the private sector and in the public sector as well. Under the 1993 production sharing contracts, which were the initial PSCs, we had broad stabilization clauses. This, in effect, allowed companies to trigger these stabilization clauses for a number of reasons. And then you're saying now that may have led to the Nigerian government learning from this and then restricting under the PIA the triggers for stabilization clauses on a going forward basis. Is that correct?
Very correct. I could not have put it any better.
Thank you. Well, you're the expert, but thank you for that. Next thing I would like to go into is renegotiation of PSCs, because under the PIA there's an option, and some international oil companies, IOCs, are taking up that option to renegotiate their PSCs. In fact, presently now, TEMPLARS are advising a number of international oil companies on the renegotiation of their PSCs now. Could you give us some context and an explanation of the impact of stabilization on renegotiated PSCs?
Yeah, thank you, Dayo. The PIA makes provision for renegotiated contracts. Now, renegotiated contracts or PSCs are those PSCs with historical claims against the federal government, which are either pending in court or arbitration, and which are presently being renegotiated. These are mostly the 1993 PSCs whose tenure are coming to an end.
Okay.
And it is expected that these PSCs will have certain base terms. One of some of the base terms are a 50% haircut the contractor will have to take in any disputed claim with the federal government.
Okay.
It can only, going forward, recover 60% of its cost of the entire production.
So it's a reduction.
It's a reduction from 100%.
They could have 100% cost recovery before. Now it's reduced to 60%.
Okay. And the contractor will have to retain only 40% of the acreage area and relinquishing 60% of the residual parts of the assets.
So to relinquish more to the government.
Yes.
Okay.
And the PIA makes a stipulation that these renegotiated PSCs must be done within 1 year of the effective date. Now you ask the question, what is the impact of that on stabilization?
Yes.
Now, if these PSCs are renegotiated within 1 year of the effective date of the PSC.
August 2021.
Yes.
Yeah.
These PSCs will continue to remain under the old regime, which is the Petroleum Act regime, and will continue to enjoy
Those incentives,
including the stabilization
provisions, which are wider.
Guarantee.
Okay.
Yes. However, where a PSC contractor, for any reason, is unable to renegotiate or conclude renegotiation within the 1 year stipulated in the PIA, then they will continue to remain under the Petroleum Act regime until the expiration of the underlying OML, from which point they transit from the Petroleum Act
regime to the Petroleum Industry Act.
To the Petroleum Industry Act
regime upon the expiration of their oil mining lease.
Yes. And the question could then be asked whether the limitations placed by Section 305 of the PIA on stabilization will apply to such PSCs.
Okay.
Now, the answer will depend on whether such PSCs are considered to be a new contract entered into after the promulgation of the Petroleum Industry Act, in which case the limitation in Section 305 will apply. Or an old contract
that has been
entered into before
the
PIA came into force, in which case the Petroleum Act will apply to such contracts, and any stabilization protection given to the contractor, PSC contractor, under the PSC
will continue
to apply. And in our view, and this is with regards to the 1993 PSCs, we've always taken the view that such PSCs are, even after their renewal, are the same contracts as the previous PSC because of their self-extending provisions regarding renewal. We say that such PSCs are a single, continued, and unbroken contracts, and therefore entered into before the PIA was promulgated.
And therefore, it has wider stabilization provisions and technically better fiscal terms under the PA, the Petroleum Act, as opposed to the more limited ones under the PIA.
Exactly.
Thank you, Wale, for that. Well, ladies and gentlemen, it's gotten a bit technical here, but very interesting and educative as well. I want to thank you for tuning in to Talking Legal with Templars. I've had the honor of having Adewale Atake, SAN, head of disputes at Templars over here, and we'll see you during our next episode. Wale, thank you very much.
Thank you, Dayo.
Okay.